So good morning, everybody. Welcome to our webinar on avoiding and defending judicial review claims. This is the third in our series of webinars for local authorities on education law. I'm Katherine Anderson, and this is my colleague Jim Hirschmann. We are education law barristers. I have a particular interest in special educational needs and discrimination law. Jim has a very busy practice in education, health and social care law, public law, and the Court of Protection. We're going to be talking, just first of all, about some of the common types of JR claims that our team see in education law. I'll be talking about what happens before the pre-action stage of judicial review, looking at how that may be relevant in terms of avoiding and defending any potential future claims. I'll be talking about the pre-action stage, and then I'm going to hand over to Jim, who's going to talk about what happens after a claim is issued, the decision to give permission, and what happens after a decision to give permission is made. So common types of judicial review claims that one tends to see against local authorities in the area of education law. Many of them arise out of the statutory framework for education, health and care needs assessments and EHC plans, whether that's a failure to complete an assessment or to issue or to amend a plan within the statutory time limits. Or very often it may be because there's a failure to secure the special educational provision in an EHC plan. There can be claims relating to a failure or an alleged failure to provide social care or to assess an individual's care needs, and that can relate often to an EHC plan. There can be claims relating to a failure to provide exceptional educational provision out of school, where a child may, for reason of illness, exclusion, or otherwise, be unable to access that education, or a suitable education rather. Otherwise, that's the Section 19 Education Act duty. They may relate to an alleged failure to provide home to school transport or policies of the local authority, for example, in relation to home to school transport, which are alleged to be unlawful. Often there can be disputes about providing a personal budget or direct payments. What can local authorities be doing perhaps pre-action rather, before there's any intimation of a judicial review claim, to avoid them or to defend them better if they come? Is perhaps obvious, but designing and reviewing policies so that they are lawful is plainly a necessary step, making sure that they are rational and compliant with the relevant law, but that there is scope within them for decision makers to depart in exceptional cases so as not to fetter their discretion. Now, we know that in relation to the field of education, health and care plans and special educational needs more widely, there is a level of demand with which the system was never designed to cope. So in relation to this particular area of judicial review that we are seeing, where local authorities are struggling to comply with the statutory duties that they know they have under the Children and Families Act, we are not pretending, Jim and I, to come up with any solutions as to how local authorities can better meet that demand. But we do have some observations that we could share, or some comments. What we are sometimes finding is that local authorities, when we are speaking to them, because there's a pre-action stage or in terms of defending the claim, there may not be notes, there may not be records of steps taken and the reasons why. And that means it can be difficult for there to be handovers. It can be difficult to find out what has happened and why and what needs to happen next. Sometimes we're seeing that standing where the parent or the young person or their representative is standing, they're not getting information and perhaps not support to participate in relevant decisions. And so that can mean that from where they're standing, they do not know what the local authority is doing, and they don't necessarily trust that what's being done is the right thing or that anything is happening at all. And something to ask is, when you are on first notice of a problem in relation to the non-performance of a duty, for example, securing provision that's specified in a EHC plan, do you have procedures in place that enable you to take the opportunity to react to that in good time? And what are you doing to follow up or overcome obstacles that you might face if you are meeting difficulties with procuring, for example, provision that's in an EHC plan? Are you ensuring that there are clear communication channels between local authority officers and between the local authority and its local partners? For example, between your education team officers and your legal department, with brokerage, with your social services team and department, with the governing bodies or proprietors of schools, and with integrated care boards. These are channels of communication that should be put in place under Section 28 of the Children and Families Act, and it may mean that you're better able to meet the demands on your service. Are you ensuring that local authority officers and decision makers understand the relevant law and what makes a decision lawful or unlawful? In other words, for example, what it is relevant for them to take into consideration when making a decision and what is not relevant? Do they know when and how to seek advice? And do they know when and how to call on other officers and departments or teams and other local partners? Do you have a process for identifying legal developments in your area? And do you have a process for regularly reviewing policies and regularly reviewing the training that relevant officers have? Next, the pre-action stage. I'm going to talk about the pre-action protocol for judicial review. There's the link to it. And going back to what the pre-action protocol is, well, it contains the steps that parties should generally follow before making or before a claim is made. And there are cost consequences if it's not followed, or at least there may well be. It's something that the court needs to take into account when considering what order for costs to make, if any, if the protocol has not been followed by either party. But it's also more fundamentally important to consider what is actually the aim of the protocol. The aims are set out in the protocol itself, but a key part of it is that it's there to try and enable parties to avoid litigation if that is possible. I'm going to talk briefly about the duty of candour. That's a duty that both parties have. What's relevant, of course, for the purposes of today's webinar for local authorities is the public authority's duty. Case law sets out that the duty of candour owed to the court is not owed until judicial proceedings have been commenced. But case law says similar considerations can be relevant in the parties' dealings with each other at the pre-action stage as a matter of good practice. And so we flag here that there's a particular obligation on solicitors and barristers of public authorities in ensuring that that duty is fulfilled. You will find that if you're instructing counsel like Jim or myself to advise you either at a pre-action stage or indeed when you're defending a judicial review claim, you'll find that we are on at you to get the information. It's not simply enough to say we can't get instructions on that. The local authority has this duty. What we have put together is a checklist of things for you to be considering when you're dealing with a claim that is coming to you at a pre-action stage, when you've got the pre-action letter from a claimant. First obvious question is, what is the proposed time limit for replying? Because that's clearly something you're going to have to diarise and plan for. Next question, do you understand the case that you need to answer? Because it may not be clear from the pre-action protocol letter, although of course it should be, but it may be that you need to seek clarification, at least in some regards. Next, and very importantly, do you have all the relevant information and know the material facts? And this comes back to the question of the duty of candour. It may be that you're going to have to allocate significant time to obtain all the relevant information and the relevant facts and the material facts from a number of different officers who may have been involved, and also to involve decision makers at a higher level of authority in order to determine what more can be done, perhaps, and to take relevant decisions. So that is something that you're going to need to plan for that could take some considerable time when you are putting together a reply. And do you need more time to reply? If you do, you can ask for it. You can propose a reasonable extension, giving a date by which you expect to be able to respond substantively and giving reasons why you are requesting that extension. Another question may be, are you actually the correct defendant? It may be that this particular claim is one that should be made against a different local authority, perhaps, or against a governing body or proprietor of a school, or possibly an integrated care board. Are there any interested parties? An interested party is a person who is directly affected by the claim, and the response should be sent to all the interested parties who are identified by the claimant in their pre-action protocol. So the point being, the response should be sent to the interested parties who have been identified by the claimant in the pre-action letter, but also contain details of any other persons who the defendant considers are interested parties. Next question, does the claimant have sufficient interest to bring the claim? Now, in most of the sorts of JR claims that we've been talking about that we commonly see, the claimant almost certainly will have. They're likely to be the parent of a child or young person, or the young person themselves. But it may be that there's a claim that's challenging a wider aspect, perhaps, of local authority policy, and there may be a question as to whether that person has sufficient standing or not. Next question is there an adequate alternative remedy? The case law has set out that judicial review is ordinarily a remedy of last resort, and claimants therefore expected to use other remedies that are appropriate and which are alternative, such as internal complaints procedures, review mechanisms, or statutory or non-statutory appeals. That said, case law flags it is a matter of discretion for the court, and if it is clear that a public authority is acting in defiance of the rule of law, the High Court may decide to step in, regardless that there may be an adequate alternative remedy. And going further into the case law there, it's setting out that what the court should be looking at is the provision that Parliament has made to cater for the ordinary sort of case, and that the High Court should be slow to step in when Parliament has clearly intended to there to be that process available. But there may be cases where that is not appropriate. A very significant question in many of the cases we see is this a matter that the Special Educational Needs and Disability Tribunal should be looking at or not? And a question that Jim has been involved with in a case earlier this year, which was particularly interesting, looking at the question of how long relevant is it that there's substantial delay in hearing cases before the Special Educational Needs and Disability Tribunal. So question, are you going to be saying that there's an adequate alternative remedy? So the next question, is it relevant to say that the claim is academic or that it will soon be? So a claim's academic if, in practical terms, the claimant is not going to obtain any practical relief that the court could give that they haven't already got. And so it may well be that you are putting forward a position that, yes, there's been difficulty getting certain provision in place for a child with an EHC plan, but that provision is now there and the matter is now in hand. That may be a point that you'll be saying, or you may be saying it'll be done in the next week. It's soon to be academic. Another question which you need to ask and answer is it highly likely that the outcome for the claimant would not have been substantially different if the conduct complained of hadn't occurred? You might have a situation, and again, using an example from the SEN framework, supposing it's being said that a block of speech and language therapy, which was specified in the EHC plan, hasn't been put in place. But it may be that the child, for other reasons, for a deterioration of health, wouldn't have been able to access that in any event. And you may say, therefore, that yes, that hasn't been secured, but it would come to a different outcome, in fact. A further question, again, less likely to come up in the sorts of claims that we are talking about. But the question is here, is the decision and the challenge actually amenable to judicial review? Most times it probably will be in this field, but it could well be that somebody is actually making a complaint about an action that they have in private law, for example, under a contract, and that this is simply not a public law claim, or at least it shouldn't be pursued as such. Next question, is this claim actually still in time? That isn't always a straightforward question to answer. And you may have a situation where there have been a series of decisions, for example, and there may be an ongoing breach of duty, or at least arguably so. So you may want to consider the merits as to whether this is actually a time point that you should be taking. Next question, what is the explanation for the decision if this challenge concerns a decision? This goes back to the need to ensure that you have the relevant information and the material facts so that you can reply. And if you've got that explanation, or you should be getting it, it may be relevant to provide a fuller explanation for the decision in your reply, if that's appropriate in the circumstances of your case. Have you actually addressed each point of the dispute? It may be that there's one you've overlooked because there are a lot of them stated in the letter of claim that you are dealing with. How strong is the claim that the local authority has acted unlawfully? You're going to need to make an assessment of the merits of it. And then you also are going to be needing to consider, what is the action that you are being asked to take? What's the remedy sought? And what would be the impact if that remedy were ordered? Relief is discretionary. It may be that what is being asked for is something that would be particularly problematic for the local authority to allow, but it might be something that the local authority is doing anyway or trying to do anyway, and the only issue is what is the time frame in which you can achieve it. Next, what are the claimant's proposals for alternative dispute resolution, and what are yours? Alternative dispute resolution is very important in the pre-action protocol. As I've set out there, the court might actually in due course require the parties to provide some evidence as to what they did or considered in terms of alternative dispute resolution, and there may be cost consequences if it's not properly considered. But quite often what we see in pre-action letters is simply a statement to the effect of, we are open to whatever ADR you might suggest, and no actual proposal. But if I go on to the next slide, the pre-action protocol gives examples of types of ADR, and those can include simply discussion and negotiation. It can be incredibly effective to offer a meeting with the officers who are involved on the ground in dealing with this matter, and a decision maker who's got proper authority to move things on. Perhaps with a mediator, perhaps not, perhaps with a representative, and to offer that meeting within a prompt timescale. That can be very, very powerful, and it can also indicate that not only are you doing all that you can, it can unblock problems that may have arisen. And it can also indicate, of course, that judicial review hasn't been necessary. There's been an alternative remedy that you've put forward, which is to sit down and resolve the problem. Next question, when you're replying and checking through, have you responded to the requests for information and documents that there may have been? Plainly, this is important under the pre-action protocol. Requests for information and documents need to be proportionate. Defendants should comply with requests unless there's a good reason not to. But this is important in a number of different ways. One of them can be simply that where the claimant is standing, it may be that they do not know what the local authority has been doing or why it's been doing what it's been doing. They may have lost trust. And if they can see for themselves what's actually been going on because they can see the information in the documents, that may well be an important part to resolving the dispute. Next part of your checklist, should the claim be conceded in full or in part or not at all? The pre-action protocol says that the reply should say so in clear and unambiguous terms. So you can't sit on the fence, you're going to have to make a decision as to what your formal response is going to be. Another point, are they asking for any interim remedy? And if so, do you oppose it? Jim will be talking a little bit more about that. Have they stated an intention to ask for an interim protective costs order? Again, what's your response? That's something that Jim will be talking about a little bit more as well. And then finally, in your reply, you will be putting forward the address that can be used for further correspondence and service of court documents. And one of the questions you'll be needing to consider when you're doing that is, are you going to be accepting service by email? Now I'm going to hand over to Jim to talk about what happens when a claim is issued and after that. Thanks, Jim.
Thanks so much, Kath. And good morning to you all. LW was a case on the slides earlier, and that was about alternative remedy and judicial review. And the court was very clear in that case that it considered the FTT, the first tier tribunal, to be an adequate alternative remedy. But just reiterating what Kath said, there's a lot of scope to resolve matters without a JR ever needing to be issued in most cases. And getting in early and resolving it is, in my experience, often the best way of staying out of the High Court and saving costs. But sometimes it can't be avoided and the claim is issued, or sometimes a claim issues prematurely. And what I want to take you through now is what happens in those circumstances and give you some sort of tips and things to bear in mind, that sort of thing. So first, an N461 is the standard form that you'll see in a judicial review. That will usually be filed with a supporting statement of facts and grounds, often drafted by counsel, and evidence in support of the claim. There is an urgent procedure, so if a decision is needed within 7 days, you might also see an N463, but the court's been pretty critical of that being used inappropriately, and it has its what's known as the Hamid jurisdiction, where it refers professionals who improperly use the urgent procedure. In many cases, pre-action protocol has been going on for weeks, and in those circumstances, it's quite hard to see how relief is needed within 7 days if someone sat on it for more than 7 days before issuing. But as we know, education cases are urgent, and you will often see an expedited timescale because the court wants to resolve it quickly. And what you sometimes see there is what's called a rolled up hearing, so where you have the permission decision together with the final substantive hearing and judgment following straight after, just because it enables the court to reach a settled decision more quickly. You'll often see interim relief applications. So whilst the judicial review is proceeding, interim relief may be sought. But if the interim relief is a particular placement, for instance, we see that a lot, then that's likely to determine the claim fully. And in those circumstances, the court might be quite slow to grant that relief. It might be more likely to expedite the timetable. But the test is similar to American cyanamide, which civil practitioners will be quite familiar with. A judge tends to consider, is there a real issue to be tried? So that is, does it have a realistic prospect of success? And does the balance of convenience lie in favour of granting the interim order? If it's going to be very inconvenient or costly to a local authority, that is going to need more justification by a claimant in order to get that interim relief. And where the mandatory relief is sought, you need to show a strong prima facie case. Sometimes they will just want you not to do something, so it might be injuncting you from, I don't know, changing an education, health and care plan until the court's dealt with the matter. Those are granted more readily than sort of mandatory relief telling you to actively do something. But when the N461 comes, it's usually the time that me and Kath get involved. We can be helpful earlier, but it's usually time to instruct counsel if you haven't already and you don't have the expertise in-house to draft your responses. So in the normal run of cases, you, the defendant, will file an acknowledgement of service alongside summary grounds of resistance, evidence that you rely upon, and an N260. The N260 sets out your costs. And that's usually due 21 days after service of the claim form. So you usually have 3 weeks. And the claimant then has 7 days to file a right of reply. And the court will then proceed to consider the documents on the papers and make appropriate directions. And that is where the court has to consider permission. Now, Section 31(3) of the Senior Courts Act is very clear that an application for judicial review shall be made unless the leave of the High Court has been obtained in accordance with rules of court. And the court shall not grant leave to make such an application unless it considers that the applicant has a sufficient interest in the matters to which the application relates. So there's a statutory basis that says the claimant needs to have standing, and also the leave of the High Court is needed if you're going to proceed with a JR. And that's why we have this permission gatekeeping tool, and that's echoed in the CPR at 54.4. The test was set out as the second bullet point shows, that claim for JR will be refused permission unless they can show that they have an arguable ground for judicial review, so a realistic prospect of success, and not subject to discretionary bar such as delay or an alternative remedy. So it's important in summary grounds of resistance to be very clear whether you're trying to get the JR knocked out because there's been delay, because there's an alternative remedy such as ADR that hasn't been considered, and that could knock out even an arguable case. But beyond that, you've got to knock it back on arguability if none of those sort of knockout blows are available. Katherine already mentioned this, but if you can also show that there would have been no difference to the claimant, even if you had acted lawfully, then that is also a good way of getting a JR knocked out at the permission stage. So a judge will consider, obviously, whether he can consider permission on the papers or wants to be addressed, wants to have oral submissions on whether or not they should grant permission. And that will play into the judge's consideration of whether they can make a permission decision on the papers or if they want an actual hearing or a rolled up hearing. I'll be thinking about deadlines. How is this case going to be ready to be heard? And does it need to be heard by a deputy judge or perhaps the divisional court, so 2 or more judges? How important is it? How complicated is it? If permission is not granted, then the defendant will typically be entitled to their cost of preparing their summary grounds of resistance. But the claimant, unless it's been declared as totally without merit, the claimant can request an oral hearing. And if they request that, the defendant is not required to attend. But in my experience, the defendant does tend to attend that renewal hearing, as it's called, because it's a better chance of knocking out the JR completely, particularly if it's already been refused on the papers. But you can't get your costs typically of attending that renewal hearing, which is obviously something to bear in mind and advise the client department about. If the judge hasn't given bespoke directions, then there are sort of standard directions that you can expect to see. And I've set them out there just so you have them as a reference when we send out the slides. The Administrative Court Guide is a new edition is published every year, and the 2025 edition has at paragraph 10.1.4 those directions. I'll just take you through them relatively quickly. The claimant has to pay the relevant fee to continue the application for judicial review. A failure to pay basically means that nothing happens. The court office will send the claimant a notice requiring payment within a set time frame, usually 7 days. Otherwise, it will be struck out without further order. So you do sometimes get claims for relief and procedural battles about whether or not the relief should be given, whether the claim should be allowed to proceed. If you wish to contest it, then you need to serve detailed grounds with any written evidence or documents not readily already filed. So this is, if permission is granted, as I've said, generally the claim form comes in, you do what's called summary grounds of resistance, which is short form resistance grounds. But if permission is granted, you get another bite of a cherry, a chance to put in detailed grounds, which usually flesh out your argument more substantively and may enable you to narrow the issues if permission has not been granted on some grounds, for instance. And you've usually got 35 days of permission being granted to do those detailed grounds of resistance. You can just let your summary grounds stand as detailed grounds. So if counsel has been instructed and it's relatively straightforward, it's not unusual for the summary grounds to be quite robust, quite full, and there's then no need to file separate detailed grounds if permission is granted. Skeleton arguments are due 21 days before the substantive hearing for the claimant, and then you generally have 7 days to prepare yours, and then the defendant's skeleton is due 14 days before the substantive hearing. Bundles can be an issue because it can be hard to agree what the relevant documents are. So co-working with the claimant's representatives is important. And it's really important that we have our ducks in a row and we have all of our relevant evidence before the bundle, and that we're able to assist the court to make the decision. That bundle is due with the claimant's skeleton, so 21 days before the hearing. And really it should be only up to 400 pages. If the evidence is more than 400 pages, generally you have a core bundle and a supplementary bundle. There also needs to be the authorities referred to in the hearing. That's due 7 days before the hearing, so after the skeletons. Generally, the court only wants 10 authorities, doesn't tend to want more than that. And if an authority is not in dispute, then it often isn't needed to be contained in the authorities bundle because the court's unlikely to hear much by way of submissions about agreed points of law. If it's the divisional court, you need one set of the hearing bundle and one set of the authorities bundle for each judge. But the claimant tends to prepare those, so it's less of an issue for the defendant. But of course, you're often dragged in terms of agreeing the index. Other required documents include an agreed list of issues, an agreed chronology with page references, a list of essential reading, and a time estimate for reading. Sometimes there's a dispute about what the list of issues are. And what the chronology says. Often claimants in particular feel quite strongly that something's happened that might be disputed by the local authority. And it's important to note that the issues list and the chronology need to be described neutrally. A couple of other warnings. Failure to file detailed grounds of resistance might mean that you can't partake in the substantive hearing. So it's more likely that you'll have a costs sanction, but compliance with rules is important, and the High Court is less tolerant of procedural breaches than is the case in the first tier tribunal, for instance. Pursuant to CPR 32.1, the court has the power to give directions and control evidence. And the court only wants the relevant information it needs to make a decision. It does not want unnecessary information. It does not want to add to the administrative court's burden by voluminous. So if the claimant is going overboard and not being cooperative at all, it may be worth in the summary grounds of resistance, or certainly in the detailed grounds, seeking directions limiting the evidence so that there's no sort of satellite litigation and lots of resource eaten up trying to agree something with an unreasonable claimant. If permission is granted, it's worth reflecting on settlement because a judge has looked at it and decided that there's an arguable claim. And at that point, it's worth going back to the client department and considering what will the impact be of conceding, what costs, consequences are there likely to be. You can usually get an indication of the claimant's costs and consider whether it's worth settling. That can be attractive because it maintains an element of control over the outcome and it reduces the publicity of a judgment of the administrative court against the client. It also limits the cost risk because the claimants will not have incurred the full costs of preparing the bundles and, of course, instructing counsel to final hearing. So it can be cheaper for the client if the case looks like it will probably succeed if it goes the whole way. If you are settling, you need to produce a draft order. Again, generally the claimant will help with that, but you will also need to agree a statement justifying settlement and any authority you're relying on as part of a settlement agreement. If a case has come out, for instance, showing that the JR is likely to succeed, then that is worth putting in the statement. Both the order and the statement need joint signatures. So again, joint working with the claimant is really important in that respect. But you typically file 3 copies with the administrative court office. If you don't comply, if only one of you signed it, for instance, the judge is likely to direct a hearing. And again, that increases cost. So it's important to get it right. The Administrative Court Guide from 2025 gives some helpful reminders for consent orders. Often in the header, you should have it expressly setting out that is made by consent. You, of course, need the signature of both the legal reps to the parties. But if you have an interested party, it can sometimes be an issue because you need to get their agreement as well. So just bear that in mind. Where the order will finally determine the claim, the manner of determination that the claim is withdrawn or that the decision challenged is quashed, that needs to be made clear. And costs also need to be resolved, whether that's going to be summary assessment by the court if not agreed, or more likely detailed assessment if not agreed. Again, detailed assessment can be very expensive, so it is worth trying to agree costs if at all possible. In terms of a statement, keep it brief, to the point, set out the brief procedural and factual background, and set out why settlement is occurring, what the specific terms of settlement are, and why they are appropriate. If you don't settle and you go to hearing, the typical format of a hearing will be the claimant addressing the court, explaining why they should have the relief sought. The defendant then has the opportunity to respond. Any interested party or intervener then addresses the court. The claimant then has a right of reply, and you then get judgment. Sometimes you will get judgment on the day, but it's not unusual for judgment to be reserved and to follow weeks or sometimes months later. There's usually another date set for the hand down of judgment. Very often, the hand down will be electronic, so the judgment will simply be emailed and then published on the National Archives, and then costs submissions will be made in writing. So costs, how are they determined? Starting with interested parties, they can recover the cost of preparing their acknowledgements of service, but it's unusual for the court to offer two sets of costs against the claimant following a substantive hearing. So if you as the local authority are brought in as an interested party, for instance, if there's a judicial review of a school, then just be aware that you might be able to get your acknowledgement of service costs, but the substantive hearing, you're unlikely to recover your costs. Interveners are not usually ordered to pay costs or able to recover them. Some exceptions to that, but look at Section 87 of the Criminal Justice and Courts Act 2015 if that arises, because it sets a checklist of considerations that the court should factor in. And remember that the court ultimately has discretion as to costs. So the general rule is the winner gets their costs, but the court can depart from that rule. And the famous case of M and Croydon LBC is the one most commonly cited for costs. It appears also in some helpful costs guidance from 2016, which you'll find if you just Google Admin Court Costs Guidance 2016. And that judgment, firstly, makes very clear that costs are fact sensitive and very much a matter for the discretion of the first instance tribunal. Having said that, it sets out a really helpful checklist at paragraph 60 to 63. It essentially says there are three types of cases. A claimant where the claimant has got everything they wanted, whether that's following a contested hearing or as a consequence of settlement. Category 2, a case where they've only succeeded in part. And category 3, where there's been a compromise, but it doesn't really reflect the claimant's claims. So that might be if a claim's been rendered academic, for instance, it's no longer relevant to pursue the claim. It's very hard there, perhaps, to see who's won. Where the claimant's got everything they wanted, generally, the claimant will be able to recover their costs, unless there's a good reason for them not to. Where the claimant has got some of what they want, the court will normally determine questions such as how reasonable the claimant was in pursuing the unsuccessful parts, how important it was compared to the successful claim, and whether the costs were increased as a result of the unsuccessful claim. Very often, the underlying facts will be the same for the successful ground and the unsuccessful grounds. And in that context, it can be quite hard to show how the additional grounds really added to the time and the costs of responding in any material way. So in that circumstance, a claimant's likely to still get costs. But if you can show that they've been vexatious or unreasonably pursued the claim, issued too early, not engaged with ADR, then that might put you in a better position to resist costs. In category 3, where you reach an agreement, for example, because the claim's academic, that puts you in a much better position to resist costs because the claimant can't really show that they've got the relief they wanted as a result of issuing the JR. Also, if there just hasn't been judgment and it's very hard because the claim is very messy and the court can't really work out who the winner was from the terms of settlement, the court is more likely to say no order as to costs. You will often see legally aided claimants. And what the Legal Aid Sentencing and Punishment of Offenders Act 2012 says, when read with the Civil Legal Aid Costs Regulations of 2013, generally it's very hard to get costs against or certainly to enforce the cost against a legal aided party, and they tend to have cost protection. So what you see is wording of the kind that I have set out at para 1, para 2, underneath the first bullet point. What it generally means is you don't get costs against a legally aided claimant. And that's worth bearing in mind when advising the client department, because it obviously will impact the bottom line budget in terms of whether you're actually going to see any money coming into the local authority, even if you win. If there's significant public interest litigation, there may also be an application for a cost capping order. So make sure you get careful advice on that if that's raised, because it can be quite expensive to deal with responding to that application, and it will impact the client's risk appetite. So you will want to advise the client about that and see how it factors into the overall case strategy.